Who are you? No, I'm kidding. I'm kidding. I just haven't seen you in a while. I didn't recognize you. The 29th is not. Any objection from the people if I go to the next day?
For barely a few seconds, and the judge is already joking. Who are you? I'm kidding. And you can feel the vibe of this courtroom right away. Friendly on the surface, but underneath, every case on this docket is about serious consequences. Competency, jail, bond, and whether people's lives move forward or freeze in place. In this session, you're going to see a full range of criminal procedure in action. We start with a defendant whose competency to stand trial is under review, jump to people who can't even be heard because of technical issues in prison facilities, and move into decisions about preliminary examinations, plea deals, and adjournments while lawyers scramble to prepare mitigation. The judge has to balance patience with pressure, move the docket along, but also make sure nobody's rights get trampled just because Zoom is glitching or paperwork is slow. As you watch, keep an eye on a few big themes. Competency versus responsibility, defendants choosing between taking a deal now or risking a preliminary exam, and how complicated something as simple as "can you hear me" becomes once you're inside the criminal justice system. Question for you. If you're facing charges, would you want your lawyer to push for more time to prepare, or would you want everything over as fast as possible? Let's see how these defendants handle that choice.
The court does call the case of the people of the state of Michigan versus Ronald Fleming.
Good morning, Your Honor. Ashley Lundy for the people.
Stephanie Cannon on behalf of Mr. Fleming, who should be appearing via Zoom. Yes. Mr. Fleming, could you state your name for the court?
Ronald Fleming.
Thank you. Your Honor, today's the date and time to go over the competency evaluation, or I'm sorry,
Competency review.
the report. And the report has been provided to me. I do believe the prosecutor has a report.
I proceed, Your Honor.
And in the report, it is indicated that my client is not competent, but they do believe he can be restored to competency within the statutory time frame. So, Your Honor, we are asking, we will stipulate to those findings, and we are asking for another hearing regarding competency.
And Your Honor, I'm sure the court recalls we've been pending competency for quite a while on this file, but the defendant, I do believe, was admitted to the forensic center in June. So he's been there now for about a month and a half. So I'm optimistic that we may actually be able to get the treatment restored and done at this point. I would request also an adjournment and would stipulate to the findings in the report as provided to myself, defense, and the court, and ask the court to continue the order for his treatment and allow him to attempt to regain competency.
And just so that we're all clear, the report that I'm looking at is the July 15th report. She needs this.
Yes, Your Honor.
Yes, Your Honor.
All right. Based upon that report, the findings are, and it's been stipulated to by the parties, that the defendant still remains incompetent to stand trial at this time. The court will then continue that finding. And I will set a review hearing. Give me 90.
October 16th.
October.
Right here, the judge formally rules that Mr. Fleming is not competent to stand trial at this time. That doesn't mean he's getting away with anything. Legally, competency is about whether the defendant understands the proceedings and can assist in their own defense. If he can't, the system is required to pause and focus on treatment, not punishment. The defense and prosecution both stipulate to the report, which means they agree with the findings. He's currently incompetent, but likely restorable within the statutory time frame. So the judge continues the treatment order, sets a new review date, October 16th, and keeps bond the same. This is the justice system trying to thread a needle. You can't fairly try someone who doesn't understand what's happening, but you also can't leave a serious case in limbo forever. What do you think? Should courts be forced to wait for restoration no matter how long it takes? Or should there be a point where charges are dropped if competency never returns?
16, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Fleming.
Thank you.
Court calls case People versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who should be appearing via Zoom. Mr. Wilson, could you please state your name for the record? Mr. Wilson, could you state your name for the record, please?
Not sure if you can hear us or not. I heard, huh? All right. I'll pass them. Hear us. Court does call the case People versus Carista Riapel.
Good morning, Your Honor. Requesting permission pursuant to Michigan Court Code 0 under the supervision of a actually long.
Oh, really? Okay, permission to practice is granted.
Thank you, Your Honor. Christina Berg, hearing for the people.
Morning, Judge Mike Gaddy, Assistant Public Defender on behalf of Ms. Riapel, who is here via Zoom. If you could state your name, ma'am.
Carista Riapel.
Your Honor, I have had a chance to speak with Ms. Riapel, and we are asking to adjourn this matter so I can visit her and go over the mitigation information that we have prepared. I'd like to do that in person with her. So I'd ask the court for a couple of adjournments so I can accomplish that.
When we get to Ms. Riapel's case, notice how the conversation shifts from "what are we doing today" to "we need more time" for mitigation. Mitigation is everything about a defendant's life that might explain, contextualize, or soften how the court views the offense. Mental health, trauma, addiction, family responsibilities, work history, you name it. Her lawyer doesn't just want another Zoom call. He wants to meet her in person and go over the mitigation packet face-to-face. That's a big deal. In serious cases, those details can be the difference between a harsh sentence and something more balanced. The judge doesn't fight it. He offers 2 or 3 weeks, and they land on August 7th for a probable cause conference. Here's the key takeaway. Sometimes the smartest legal move isn't to rush into a hearing. It's to slow down and build the full story behind charges. If you were in trouble, would you be willing to wait in limbo a little longer if it meant your lawyer could present a stronger, more human picture of you to the court?
So you want 2 weeks or 3 weeks out?
Maybe 3 weeks, Judge.
August 7th. I think it's okay. Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you, Judge.
Thank you.
Continue. Thank you. Court calls case People versus Amanda Scarduch.
Morning, Your Honor. Mariah Berg, Assistant Prosecutor appearing on behalf of the people.
Good morning.
Good morning, Your Honor. Kerma Dadush on behalf of Ms. Scardudis. Ms. Scardudis, can you please state your name for the record? Oh, she's not unmuted.
I don't know if she can. Where is
Amanda?
she? She's at MDOC.
Can you try to see if someone can unmute you at MDOC?
You're trying to force it.
Amanda, can you please say your name for the record?
I don't know if she can hear us. Yeah, but she's not responding. They're at different facilities, correct?
No.
Yes.
Oh,
The 2 that couldn't hear me, because I got 2
Oh.
that are unmuted but cannot hear me. All right, I'll pass that matter.
thank you, Your Honor.
You'll contact or try. Court does call the case People versus Mariah Thomas.
Kerma Dadush on behalf of Ms. Thomas. Ms. Thomas, can you please state your name for the record? Okay.
Ms. Thomas, if you can hear me, if you can wave your hand, I would appreciate it. Yeah, I'm not getting.
My name isn't Miss Thomas.
Yeah, I was gonna say, I don't think that's her.
Okay, what
No.
is your name, ma'am?
My name is Anitra Coomer.
Got her.
Judge,
She was adjourned via STIP.
She was adjourned.
And Ms. Coomer, just for the, I'm coming to see you on Monday. I have.
Okay.
Yeah.
Okay.
All right, sorry about that. I
Okay.
guess it was adjourned
That's
via
fine.
step. Thank you, ma'am.
Yeah.
Maybe they can put Amanda in there.
Pardon? So do we have Miss Thomas?
So that was Ms. Thomas. because-
Yeah.
Yeah, so no, we don't have.
This is the kind of Zoom-era courtroom chaos that would be hilarious if it weren't happening in real criminal cases. The judge calls Mariah Thomas, tries to confirm her identity, and ends up talking to someone whose name is actually in each truck. For a moment, nobody is sure who is who, where they are, or whether the right person is even on screen. From a legal standpoint, identity is fundamental. The court has to be absolutely sure the person on the video is the defendant named in the case. Mix-ups like this can lead to confusion, delays, or worse if not caught. To his credit, the judge keeps his cool, double-checks names, and ultimately realizes this isn't the right person for that case, and that matter has been adjourned anyway. But think about this. If you're incarcerated or in a facility and you depend on other people to unmute you, bring you to the right kiosk, or log you into the correct hearing, how much control do you really have over your day in court? Is that fair, or should there be stricter requirements on prisons and jails to make sure defendants are properly connected and identified?
This is going well.
Well,
So you want to adjourn that out?
well,
Was she,
Miss Thomas's?
pardon?
No.
Is Miss?
Ms. Thomas is in the NDOC, dates of April 11, when that facility signed.
Oh.
Tonight, so I'll sign it early. I can come.
Okay, so she's at 11.
Yes.
We are adjourning Amanda, but I think she has to stay here name for the record anyway.
Yes, she does.
Okay, thank you.
Well, I have to make sure it's her too.
I believe that is her.
Amanda? I just don't know why we don't have. That's it, Huron Valley.
Yes.
See if you can get through to them. Court does call the case of the people versus Denell Young Senior.
Good morning, Your Honor. Jeff Dean, Special Assistant Attorney General, here on behalf of the people.
Good morning.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Young, who's here to my right. State your name, Mr. Young.
Denell. What are we doing?
Your Honor, I did have a chance to communicate with Ms. Williams from the AG's office. At this time, Mr. Young would like to set this matter for the preliminary examination.
All discovery is complete.
Yes, Your Honor.
The people have their witnesses available the 29th.
29th, yes, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That's before Judge Barr.
One thing, Your Honor.
Bond will, thank you. Bond will continue.
Thank you, Judge.
Your Honor.
Now we get to something every defendant dreads, the take it now or lose its speech. After Mr. Young's preliminary examination is scheduled, the prosecutor jumps back in to make a very clear record. There's been a pre-preliminary exam offer, and if this case actually goes forward to that prelim date, the offer will be withdrawn. This is classic plea bargaining strategy. The prosecution is basically saying, you can get a better deal if you plead before we put on evidence. But if we have to go through the prelim, that deal disappears. Mr. Young confirms on the record that he understands this. His lawyer even explains that it's the standard type of offer the office usually makes. Here's the tension. Defendants are under serious pressure. Do they exercise their right to a preliminary exam where the state has to show probable cause, or do they lock in a safer deal now and give up that chance? If you were in his shoes, would you roll the dice on the evidence or grab the deal before it vanishes?
9 a.m. before Judge.
Judge Washington.
Judge Washington. Who are you? No, I'm kidding. I'm kidding. I just haven't seen you in a while. I didn't recognize you. The 29th is not. Any objection from the people if I go to the next day?
We're gonna check once to make sure he's there. Okay. Just make sure he's there. All right. Yeah, yeah.
Set preliminary examination August 5th, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case of the people versus Jessica Hæpner.
Your Honor, as a red folder requesting permission to cap this under NCR 8.120 under the supervision of
Who? He has an intern?
Yes, several.
He does?
Very good.
He's not old enough. All right, permission to practice is granted.
Thank you. I've got a nice folder for them.
Thank you, Your Honor. Today's the date and time set for probable cause conference. We are just asking for a brief adjournment at this time. The court should have the.
Did you state your appearance?
I'm sorry, Judge Cabral on behalf of Ms. Hæpner. Ms. Hæpner, please state your name for the record.
Jessica Hæpner.
Thank you.
Judge, we're just asking for an adjournment.
You're looking for an adjournment of this?
Yes, Judge.
All right. You want the 31st or the 7th?
The 7th? The 7th, please.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
When Tariq Wilson's case comes back on the record, we finally hear what's been going on behind the scenes. His attorney explains that contacting him through the prison system isn't as simple as picking up the phone. She had to start a lengthy approval process just to be added as someone allowed to visit or speak with him. Forms filed, applications submitted, and she's still waiting to be cleared to come into the jail. Legally, that's a big issue. A defendant has a right to effective assistance of counsel, which includes meaningful communication. If it takes weeks just to arrange a conversation, how is anyone supposed to make smart choices about pleas, prelims, or mitigation? The judge responds reasonably. He grants the adjournment out to August 7th to give her time to get approved and actually meet him. Imagine facing serious charges and your own lawyer can't talk to you freely because of administrative red tape. Do you think courts should push facilities to speed this process up, or is this just the price of running a secure institution?
Bond continue.
Thank you, Judge.
Thank you, Judge.
Wait up in the hallway for me. I can talk to you.
I think something happened the first time, so let me call your case. Court does call the case, recall the case of people versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who is appearing by Zoom. Mr. Wilson, could you please state your name for the record?
Tariq Wilson.
Thank you. All right, what are we doing?
Your Honor, I do believe I turned in a German form on this. When I attempted to make contact with him, MDOC let me know that I had to go through a lengthy process. I've started that process. He can add me to his phone call, to his visitations, and I should be able to speak with him. But in the meantime, I have filled out the application, turned it in, and I'm waiting to get approved as somebody who can come to the jail. So I'm asking for an adjournment. I do believe I asked for a 3-week adjournment because of the process.
That objection, probable cause, August 7th, 2025. Thank you, sir. Court does call the case, people versus Ramen Mohammed.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Cabral on behalf of Mr. Ramen. Mr. Ramen, please state your name for the record.
Rahman Mohammed. All right.
And Your Honor, we will be waiving the preliminary exam today. I have a form I'm going to ask Mr. Mohammed to sign. All right.
And sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses are committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both.
Here, we get a textbook example of a defendant waiving the right to a preliminary exam. Mr. Muhammad is asked directly if he understands what he's giving up, a hearing where the prosecution would have to show probable cause that the offenses were committed and that he committed them. He says yes. He's told that instead of that hearing, his case will go straight to circuit court for further resolution. Again, he says yes. The judge then confirms the people also waive their right. And just like that, the preliminary exam is off the table and Mr. Muhammad is bound over on both counts. The court enters a not guilty plea on his behalf, sets a pretrial date with a circuit judge, and bond continues. This is how a lot of felony cases move up, quietly, through formal waivers and scheduling, not through dramatic courtroom confrontations. So why would someone waive a prelim? Maybe the evidence is strong and they don't want to tip their hand early. Maybe there's a plea discussion in the works and everyone wants to move things along. If it were you, would you insist on seeing the state's evidence at a prelim, or would you trust the strategy to skip it and head straight to negotiations in circuit court?
Your turn.
Judge, this time, waive formal reading, stand mute.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
With Judge Simpson.
July 29th, 2025, 1:30, Judge Comfy.
Thank you, Judge.
Thank you. Bond will continue. Lee, can you her sign off on it? Court does call the case of the people versus Matthew Brown. Matthew Brown.
Yes, I am here, Your Honor.
Correct. Ms. Constantino.
For some reason you can't get through.
Sorry, Judge.
No,
I hit the wrong button. Good morning, Your Honor. Christina Costantino on behalf of Matthew Brown.
Hey, good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
all right.
And
And what are we doing?
Your Honor, I was just recently appointed to Mr. Brown's case, given that we would be asking for an adjournment of the probable cause conference.
All right. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond will continue.
Thank you very much.
Thank you.
Thank you.
Amanda. Court recalls the case of People versus Amanda, is it Scardudis?
Yes, sir. Yes, sir.
Here's now.
Good morning, Victoria Burton here, Chief Assistant Prosecutor again appearing on behalf of the people.
And Kelma Dadush on behalf of Ms. Scardudis. Ms. Scardudis, can you please say your name for the record?
Sure, my name's Amanda Lynn Scardudis.
Thank you.
Your Honor, we have come to a plea agreement. Unfortunately, we came to that agreement after the plea form was due. So we're asking for a very brief adjournment so that we can have that ready for the next court date.
2 weeks out, that was July 31st, 2025, 9 a.m. Bond continue.
Thank you. Ms. Scardudis, I'll talk to you, okay?
Okay, thank you so much. Y'all have a very wonderful day.
Thank
do
you.
the same. Thank you.
Thank you.
Here, he'd shoot it.
I'm not.
You're not gonna, darn. All right. Court does call the case, People versus Andrew Patton.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Patton. Mr. Patton, can you please state your name for the court?
Andrew Spencer Patton.
Thank you. What are we doing on these?
Your Honor, with regards to the case number ending in 5110, it's my understanding that discovery is complete to my knowledge, and we would be asking to have that matter set for a preliminary exam. But with regards to his other matter ending in 5154, I have just been appointed last evening to that matter, so I would be asking that the PCC be adjourned so I can obtain discovery.
In the case ending in 5154, probable cause conference will be adjourned due August 7th, 2025, 9 a.m. Bond on that matter will continue. On the other matter, would the people have their witnesses available? Would the parties be available? Will the 29th work, or did you need another day?
The 29th will work, Judge.
Will? Okay, fantastic. All right. Preliminary examination in this matter will be set in person, July 29th, 2025, 9 a.m.
The Andrew Patton segment shows how messy things get when a defendant has multiple cases at the same time. One file, ending in 5110, seems ready for a preliminary exam. Discovery is complete, everyone's on board, and they lock in July 29th before Judge Washington. The other case, ending in 5154, is a different story. Counsel was just appointed late last evening and doesn't even have discovery yet. The judge essentially splits the difference. For the newer case, he adjourns the probable cause conference to August 7th, so the defense isn't flying blind. For the older case, he moves forward and sets the prelim as usual. This is the system trying to be fair and efficient at the same time. You don't slow down one ready case just because another one isn't, but you also don't force a lawyer to defend a case they've barely seen. If you had two separate sets of charges hanging over you, would you want them moving together so everything's resolved at once? Or would you prefer one to move ahead faster while the other lags behind?
That's before Judge Washington. Calls the case, People versus James Williams.
Christina Costantino appearing on behalf of Mr. Williams. Mr. Williams, can you unmute and state your name for the court?
Yes, ma'am. James Williams.
Your Honor, this is a date and time set for PCC. We have been working on mitigation, but our mitigation specialist does need some additional time to complete a mitigation report. Given that, we would be asking for an adjournment of the PCC.
Without objection, August 7th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge. Have a good rest of your day.
Thank you.
By the time we reach James Williams and the later cases, a clear pattern has emerged. This docket is all about timing, preparation, and rights. We've seen a defendant found incompetent but undergoing treatment to be restored. We've watched lawyers ask for adjournments to prepare mitigation, complete discovery, or simply get clearance to speak to clients in custody. We've seen preliminary exams scheduled as crucial checkpoints. And in at least one case, we've seen that right knowingly waived, sending the defendant straight to circuit court. The judge's job here is part traffic controller, part teacher, part guardian of due process. He keeps bond decisions steady, sets new dates, makes sure offers and deadlines are clear on the record, and tries to stop Zoom confusion and facility mix-ups from turning into actual violations of rights. For the defendants, every adjournment, every waived hearing, and every expired offer can change the direction of their lives, sometimes quietly, with just a new date and a few words on the record. So now it's your turn. Who do you think made the smartest strategic moves in this session? The ones who asked for more time, the one who waived the prelim, or the one pushing toward a full examination? And do you think this court handled the balance between efficiency and fairness the right way? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.